when you're talking about liberty and people's rights, it's often best to describe them in terms of unalienable rights and not constitutional rights, because constitutional rights are mentioned in the federal constitution or the state constitution. Either way, it is a constitutional right, but those can be modified. Look at alcohol prohibition during the 1920s. The 18th Article of Amendment to the United States Constitution imposed prohibition, but the government cannot acquire authority by manufacturing documents. Furthermore, no matter how clear the constitutional text is, that doesn't stop the government's puppet judges and the government's kangaroo courts from vomiting forth far-fetched judicial misinterpretations, where the text of the Constitution does not lend itself to that misinterpretation. Now, when that happens, of course, and you discuss a constitutional right, your opponent will invoke a constitutional ruling, a Supreme Court ruling, whether it's the United States Supreme Court or the state Supreme Court, has settled that point. And they even name the case. And one fun way to disarm them is to say, please explain why you agree with that ruling. And they're stunned. You mean you have a choice whether to agree with a constitutional ruling? When legislators make their oath of office, they swear that they will, or affirm that they will discharge their duties agreeably to the Constitution of the United States and the state. But that doesn't say anything about the far-fetched judicial misinterpretations. So notwithstanding those misinterpretations, the state constitution says what it actually says. Please explain why you agree with that ruling. They're stunned. It never occurred to them that they had any choice.